Welcome back to the Emily Show. So much has popped off in the law that this week's episode is actually getting broken up into two. So welcome to part one, because though there's a lot going on with the Jay-Z cases and Diddy's got a new indictment, that's going to have to come later because the amount of filings in the Karen Read case have just not slowed down. And I'm on spring break this week, so I'm not going to be streaming, but I wanted to know what all of these filings said when I saw them, and I know that you do too. So we are going to go over them as quickly as I can. And there was a really interesting new filing among tons of new filing in the Idaho case that I'm sure you've seen some headlines about. And I want to just go through that one filing regarding some of the text messages from the surviving roommates and the victims in the Idaho case with the prosecution of Bryan Kohberger. We are going to go over all of the motions in limine another time because those motions are coming up for hearing at the beginning of April. And I want to go through the motions and the responses and talk about what evidence at trial is looking like. But with a case that's been so under seal, we just don't have a ton of information in Idaho. And so everything that comes out in the filings about the motions in limine become incredibly interesting because it's not stuff that we know. And of course, there's some real interesting rulings from Judge Cannone in Karen Read. So lawyer filings, stuff that the court ruled on, and, well, text messages in Idaho. Let's roll the intro. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. Starting in Idaho, all of the motions in limine are starting to come in, and responses are going to be due later this month ahead of a hearing in early April. That hearing's going to go on while the Karen Read case is likely in jury selection, so don't worry, I'll be covering it. Motions in limine are the motions regarding evidence in the case. Your Honor, this thing's not hearsay because of this, and so it should come in. And we saw that motion with regard to the 911 call in Idaho, where the prosecution cited an earlier ruling by Judge that the 911 call was properly admitted at the grand jury that we don't know a lot about because grand juries are secret, but we do know that there were motions partly under seal to dismiss the case because of the grand jury. And one of the arguments there was that the 911 call was improperly admitted, but we saw now that ruling from Judge in the filing with regard to the 911 call, and we saw a little bit more details about that 911 call. We're going to go over those just real briefly, but yes, 911 calls are allowed into evidence. So yes, this motion in limine going through the legal of why a 911 call is allowed in is necessary, but it's also going to be allowed. It's going to fall under numerous hearsay exceptions. What we're looking at right now was filed on February 24th, 2025, but these have recently hit the docket. So that is why we are taking a look at them right now. This is the state's redacted motion in limine. It had been sealed. They have now been redacted. We're going to look at a little bit more information about the 911 call. Some of this is new information. Some of this is information that has been speculated about, and they are breaking down what happened in the 911 call. I think it is a little bit sanitized, but it talks about individuals. I'm not going to speculate on the identity of any of those individuals because this is redacted beyond what it says. But it says HJ and the name's been redacted. All of these will be initials until they testify at trial, and then we will see them testify at trial and hear this 911 call when this goes to trial, starting at the end of August. HJ located the unresponsive body of Xana Kernodle and informed BF and DM to call 911. EA was also present at the time, so 4 people in the house discussing this. All declarants personally perceived the event that Kernodle was unresponsive. The majority of the declarants were describing to dispatcher Carolina Calvin what they were perceiving, i.e. the present sense impressions. So describing the scene as they were seeing it. Those statements relating to Kernodle being passed out and not waking up, which is an interesting way to describe it. I want to hear the 911 call at this point for myself because I have questions. It goes on to say the declarations were made immediately after HJ had discovered Xana's body. Some declarations made would also be considered excited utterances. Those statements include, oh, and they saw some man in their house last night. Yeah, as well as they describe it as heaving, breathing, and crying that can be heard throughout the call. The 911 call is also picking up other things that are going on in the room with all of the individuals in the room as they are describing what they're seeing. but that's new information to me. Oh, and they saw some man in their house last night. We knew that that has been brought up in this case multiple times from other information. I did not know that was also in the 911 call. They say that the statement regarding a person being in the home is in direct response to why Xana might be passed out. All statements are made while the declarants are processing what is happening and were made before an opportunity to reflect and fabricate why Xana was unconscious. Clearly, the statements of BF, DM, EA, and HJ and the dispatcher fall within the hearsay rule exceptions. And then they talk about judges ruling that the 911 calls are not hearsay. The motion goes on to say, regarding the emotion in the caller's voices, Judge further ruled that the evidence was relevant as to why law enforcement was sent to 1122 King Road, and as opposed to just sending EMS for a call of an unconscious individual. This testimony was deemed relevant for the effect that it had on the dispatcher and was not cumulative to other testimony. So not only what was said, but how it was said is effect on the listener. So we're seeing a couple different hearsay exceptions being argued here by the prosecutor. Again, 911 calls fall under a myriad of hearsay exceptions and will be heard at trial. Also, those witnesses will likely be at trial and be questioned about it. Will all of them or some of them? It's unclear, but we will see as this case moves forward. And I will just make a note because I do have questions about the 911 call. I also want to hear it in total, which we haven't. We don't have the total information of that 911 call. It is odd to describe what we know happened inside 1122 as unconscious. However, I will say that oftentimes when people are significantly shocked, distressed, perception and words can be difficult, which is why I want to hear not just what's being said, but how it's being said. So when I note that I have a question there, it's because I have a question there, but it's also why people come into court to testify, so they can be asked about it and offer response. I don't have any more thoughts on that until I hear it, and that's probably not going to be until trial, other than that question mark that I think, well, is a reasonable question mark. And next, we're going to take a look at the state's motion in limine regarding the text messages, which is what I'm sure you've been seeing lots of reporting on because it is new information to us in a case that has been so sealed. Anything that comes out is like, wait, what? So let's take a look at what prosecutors are arguing to allow in text messages into this case and what those text messages are. This was also filed on February 24th, 2025. It is the redacted state's motion in limine regarding text messages, saying that the text messages of DM on November 13th and testimony from DM and BF regarding their conversations with each other on November 13th, 2022. The phone records were discovered on the hard drive of DM's phone extraction provided on April 5th, 2023, and State's Exhibit 18 from the grand jury record. They go on to say the testimony of DM and BF was provided to the defense as part of the grand jury record. So they are arguing that these are admissible, that there are text messages, where they came from, and that testimony regarding these text messages has already been had by the grand jury in this case. The government argues that DM's phone records contained within Exhibit S1 for November 13th, 2022, and BF's testimony contained in Exhibit S2 as to what DM told her should be allowed at trial. In the case at bar, they say starting on November 13th at 2:10:29, and then it is redacted. But based on the timing of this, I'm assuming it is AM because that's how we know things went down. But as they're redacting out the names, there is no AM or PM with it. But if it is a military time, that it is very clearly AM. So that's what I'm going with. But they say in the case at bar, starting on November 13th, 2022 at 2:10:29, DM sends a text message to EG, an Uber driver, to inquire if he is driving. The state submits this text message exchange is not hearsay because it will not be offered for the truth of the matter asserted, whether or not EG was driving. It's offered to show a timeline for the night of DM awake and texting at 2:10:29. From 4:19:07 to 4:21:50, DM attempts to call BF, Xana, Kylie, and Madison. All of those calls were unanswered. The records of these calls are not hearsay. They argue as they each do not meet the definition of a statement, an oral assertion, right? They're phone records. So that calls went unanswered is not hearsay. It's really a business record. The state then lines out the following text messages. From 4:22:08 to 4:24:27, DM and BF send the following text messages. DM to BF, no one is answering. DM to BF, I'm really confused right now. And if you are watching this on YouTube with me, you'll see that I am interpreting text into text to speech. I'm not reading them literally because that text is literally, I'm RLLY, confused RN. So yes, my brain has just transposed it into text. DM to Gonsalves, Kaylee. DM to Gonsalves, what's going on? BF to DM, yeah, dude, WTF. BF to DM, Xana was wearing all black. DM to BF, I'm freaking out right now. DM to BF, no, it's like ski mask almost. BF to DM, shut the fuck up, STFU. BF to DM, actually. DM to BF, like he had something over his head and little ND, which I think is probably and mouth. Then DM to BF, BF, I'm not kidding. I'm so freaked out. These texts are going to come in court and be testified to in court. But it shows what was happening in the house that night in a way that we have not seen yet. But I know there's been a lot of talk about what the evidence is in this case and isn't in this case. And I have come down strongly on the side of there is so much that we don't know in this case. And it's going to be that way till trial. And this starts to illuminate there is so much we don't know in this case. And it's going to be that way until trial. So DM texts BF, I'm not kidding, I'm so freaked out. BF texts to DM, so am I. DM to BF, my phone is going to die, fuck. BF to DM, come to my room. BF to DM, run. BF to DM, down here. The prosecution goes on to say all of the above declarations are present sense impressions and excited utterances. That those texts were them talking about what they were experiencing in the moment. And those experiences are capturing almost a log of what's happening in the moment, so they are not hearsay. They say that this is supported by DM's grand jury testimony, where she indicates she just witnessed a startling event, i.e. heard noises in the residence and saw an unknown male in the residence. The declarations indicate both BF and DM are trying to make sense of the startling event contemporaneously or immediately following that event, which goes to the standard for the present sense and excited utterances. They go on to say that at 4:24:39, DM calls Ethan Chapin, and that goes unanswered. Then they argue that the phone record is a business record and is allowed in under the Rules of Evidence 801. They say that DM and BF continue to text, and at 4:24:58, DM texts BF, I'm scared though, and then responds at 4:25:16, yeah, IK, I know, but it's better than being alone. Again, both statements are admissible as present sense impressions. They go on to say at 4:27:47, DM calls Gonsalves, the call is unanswered. At 4:28:44, DM calls Xana, the call is unanswered. So the phone records are going to come in of the roommates who are surviving, trying to reach the other roommates to establish a timeline of when the other roommates are not interacting or answering their phones. We saw this be incredibly important in the Murdaugh case. The use of phones and lack of use of phones, especially when people interact with their phones frequently, can establish a very powerful timeline because the timeline's unimpeachable. When the four victims in this case stopped using their phones is going to matter. And we've got it in context with when the other roommates in the house are talking about what they heard, what they're experiencing, how they feel. And that timeline is going to be laid out not just in phone records, but also in testimony. It can be incredibly powerful. The government goes on to say at 4:32:57, DM sends a text message to Gonsalves saying, please answer. And then they go on to say the next morning, DM sends the following text messages at 10:23:23 to Gonsalves, please answer. To Mogan, are you up? To Gonsalves, are you up? The text messages are not hearsay because, again, they are not for the truth of the matter. They are for the actions. They go on to say at 11:39:09, DM has a text exchange with her father. These statements are not hearsay as they will not be introduced for the truth of the matter asserted, but to show the timeline. At 11:55, DM receives a text message from Jay stating, bro. This text message will not be introduced for the truth. At 11:50:58, DM calls EA. Then they say at 11:51:01, DM receives a text message from Jay and a vandal alert at 1:04:01, and that those are all going to timeline. They go on to say that the state anticipates that both DM and BF will testify at trial. The state intends to ask each witness about statements made to them on November 13th, 2022, and that the testimony should replicate the testimony they provided at the grand jury proceedings, and the state submits the statements from both DM and BF to each other are allowable hearsay because they are present sense impressions or excited utterances. So the state indicates that it's going to elicit from both individuals the full conversation, not just what DM said, not just what BF said when BF testifies, but the whole conversation to allow them to say, I said this and then they said that, and both of them will testify. Oftentimes what the other person told you could be hearsay if they're not the one testifying, and the state is laying out the different exceptions to that so that at trial, they're not at sidebar arguing about this. That's why we have motions in limine. The testimony that the state thinks might be objected to by the defense, they're lining it out now so it can be argued before trial happens, and the defense is doing the same. We think the state's going to object to this, so we want the court to rule in advance. Motions in limine are to help it go faster when you get to trial because the rulings have already been made, and then the attorneys aren't whispering at sidebar about the exceptions to the hearsay rule. They end that motion talking about phone records and the fact that previous rulings have been made about this. These are some of the common exceptions to the hearsay rule that are not going to be unfamiliar to the court or counsel. So really think of the motions in limine as kind of a preemptive, hey, Your Honor, this might get objected to, so we want to make sure we have our record clear. But I think what's helpful to remember in this case in particular is how much we don't know and how much we will learn as this goes to trial. The text messages are heartbreaking. They clearly show a level, to me, of fear and what the roommates were trying to process. We are going to learn more, and I suspect a lot more, about what is known about what happened in this house during the crimes. All of that testimony is going to be difficult. These witnesses' testimony is going to be absolutely heartbreaking, I imagine, because we know that they found their roommates and friends and called law enforcement and were in the house. We know that they were scared. We know that there are things that they heard. And you hear those things in real time in the text messages, which is incredibly helpful for the state because after an event like this, it can be very hard to remember how somebody felt, what they were experiencing, what they were saying during that time looking back. So having the text messages and the phone records will help the state establish a timeline that doesn't rely on the witness's memory after a traumatic event. This trial is going to be a very long one. It is going to be difficult, but there's also going to be a lot of technical data that I'm interested to see because, again, it's not just about what happened on King Road. It's about who is responsible for what happened on King Road. And I suspect there's a lot about that we also don't know. And speaking about a lot happens at trial, we need to go to Massachusetts. So, as we get to Boston, Emily, what do we have? Well, today we have a bunch of new filings. And by the time this goes live, well, thankfully it goes live on Monday, but I'm sure there will be more filings during the week as well. And I will get to them when I am back. And I will try to touch on some of them in the Law Nerd Lounge, but I'm going to be traveling and I am unsure what cell reception will look like because we're spending some time for spring break with the family before a summer that seems like it's going to be chock full of me covering trials. So we have an answer on the question of whether or not attorney Mark Bederow will be admitted pro hac vice. We have a ruling with regard to the motion for sanctions and the dog bite expert. We have the Commonwealth correcting the record, asking for more time and asking for a whole lot more information. And we also have a filing from the defense with additional exhibitees. So I think I'm just going to go in that order and we're going to talk about all of it. Remember, as we look at the motion for pro hac vice, that hadn't been ruled on yet because the defense needed to submit an affidavit. And that affidavit was submitted on March 7th, Friday. This affidavit is filed by attorney Yannetti asking for Pro Hac Vice admission of Mark Bederow, saying that he is a experienced lawyer. He is a member of good standing of the New York bar, that he has experience with complex criminal cases, that he has worked as a prosecutor in New York, and that there is good cause to allow the attorney to come into the case because the attorney has specialized skill and knowledge in representing criminal defendants in matters of this nature. They go on to say, as the court is aware, and remember, this is what prosecutor Hank Brennan brought up in the, we're not objecting, Your Honor, but there's some information we want you to know. The defense addresses it and says, as the court is aware, Mr. Bederow presently represents Aidan Kearney, and you guys might recognize that name or might recognize him by his handle on social media, Turtle Boy. Either way, on 3 criminal cases in Massachusetts. One of those cases involves several witnesses who are scheduled to testify against Ms. Reed. Prior to the filing of this motion, Mr. Bederow conducted separate and extensive discussions with both Reed and Kearney. He, being Bederow, defined and explained actual and possible conflicts, which is the question here, right? Are there conflicts? He explained actual and possible conflicts of interest and the concept of waivable conflicts. He explained to Ms. Reed and Mr. Kearney the possible conflicts that could arise in his representation of both in separate matters. He answered any questions either client asked. He reviewed the rules of professional conduct with both of them. He presented both of them with copies of the rules. He instructed both of them to speak with separate counsel, and they had an opportunity to discuss the issues with separate counsel, which is the way to address conflicts. It seems like that wasn't done in the Idelson case. And remember, the day trial was supposed to start. Everything went completely sideways, and all of the attorneys ended up off the case. That is one of the conflict concerns here, is that if that goes down the same way it did in like the Idelson case, that you can end up with all of the attorneys conflicted out of a case, which is a question that I have here, but I don't know what the prosecution intends to bring up. The defense isn't going to bring up anything with regard to any of the cases going on with Turtle Boy. It goes on to say, after both clients expressed an interest in his representation, after they consulted their own counsels, Bederow prepared a detailed written explanation of possible conflicts and what could happen in the event of actual conflict. Both clients, with the advice of their own counsel, A, acknowledged they understood the issues, B, confirmed that they wanted Bederow to represent them, C, executed written waivers of any possible conflict, which didn't happen in the Idelson case. The affidavit goes on to say that both Bederow and I being Yannetti writing this affidavit, can unequivocally confirm that there is and never has been a joint defense privilege between Reed and Turtle Boy, and that Bederow has never shared protected material provided to him as a part of his representation of Mr. Kearney. Mr. Bederow has not shared any protected material provided to him as part of his representation of Mr. Kearney with Ms. Reed or her counsel or anyone else. They go on to say Bederow has never engaged in any conduct during his representation of Turtle Boy or anyone else for the purpose of harassing or intimidating witnesses against Ms. Reed and or Mr. Kearney. Bederow will not share any protected material provided to him on Ms. Reed's case with Mr. Kearney or vice versa, which is a hard thing to create when it's you to create like a wall in your own brain, but it's not something unfamiliar to lawyers. It could create a problem depending on what the prosecution intends to do with any of this. They go on to say that Bederow had no role in the preparation of a recent motion filed with this court, which led the Commonwealth to seek sanctions over an alleged violation of a protective order due to the inclusion of a text message sent by Michael Proctor. Bederow was not provided any protected material by Karen Reed, her counsel, or anyone else. Shortly after that motion was filed, Turtle Boy's attorneys filed a motion to dismiss the indictments against him. That motion included references to some text messages and electronic communications that were subject to a protective order in that case. The publicly filed version of that motion, which is available for this court's review, includes redactions of any messages that are subject to the protective order in that case. In a footnote, there's a reference to a series of many inappropriate statements by Michael Proctor, all of which were in the public record before the motion was filed. So this is the additional affidavit filed by Yannetti with regard to Mark Bederow. Well, this court doesn't rule quick, but did in this case. This is the decision and order on defendant's supplemental motion for admission Pro Hac Vice of Mark Bederow. And again, I know you get the pop-ups in this episode, but Pro Hac Vice is for this case, like for this cause, because this is an attorney licensed in New York, not Massachusetts. So you have to have permission of the court to appear in the case. And the court has denied that permission, saying, after a review of the pleadings, the defendant's supplemental motion for admission pro hac vice of attorney Mark A. Bederow is denied. The quote-unquote affirmation submitted in support of this motion is insufficient on its face. Oh boy, the court's not going to mince words on that then. In addition, the proposed concurrent representation involves a conflict of interest that is not waivable under Massachusetts Rules of Professional Responsibility, which is Rule 1.7a, b, and comments 22 and 23. One such conflict is specifically outlined in the motion at paragraph 8, where Mr. Bederow, apparently speaking through Mr. Urinetti, the court really wanted Bederow to file his own affidavit, it seems. The apparently is giving it away. Where Mr. Bederow, apparently speaking through Mr. Urinetti, promises to restrict his use of certain information. The clear inference of the promise is that Mr. Bederow would not use protected information gained in the representation of one client for the purpose of his representation of the other client. He thus proposes to ignore information known to him through his representation of one client, even where the information might benefit his second client. The court cannot permit such conflicted representations and declines to add to the defense team that currently numbers at least 4 lawyers, 3 by admission pro hac vice. Order. Defendant's supplemental motion for admission pro hac vice of Mark A. Bederow is hereby denied. I understand the court's concern as to conflict. I'm not quite sure how mad the court is based on the tone of this order, but the court's not thrilled. And we're seeing the Commonwealth ask for all of the information from Turtle Boy's cases. And we need to take a look at that. So the Commonwealth has said that would be nice to have with regard to the case files in Turtle Boy's cases. And they filed this on March 6th. Let's take a quick look. The Commonwealth is asking the court to issue a court order ordering Special Prosecutor Cosgrove to produce to the Criminal Clerk's Office of the Norfolk Superior Court, 1, the cell phone extraction reports and all underlying data from 2 phones searched pursuant to search warrant, and they outline the numbers as outlined on pages 15 and 16 of the Commonwealth versus Aidan Carney. In support of this motion, the Commonwealth states the following. On June 9th, the defendant was indicted by a Norfolk grand jury for second-degree murder, manslaughter while operating under the influence, and leaving the scene of a personal injury, death in violation of the code section. On April 16th, 2024, a 10-week jury trial commenced. In addition to 3 indictments, the jury was instructed to consider 2 lesser included offenses, and I've gone through those fulsomely. They say that the records are evidentiary and relevant. Remember, the Commonwealth was arguing that records regarding the investigators in this case from the Birchmore case are not relevant, but they are arguing that they now want the phone records from Turtle Boy's other cases. They say the Commonwealth intends to file a motion in limine to admit such phone records, documents, witness testimonies, and other information demonstrating intimidation of witnesses as consciousness of guilt evidence. I have said repeatedly that this second trial is going to be much different than the first trial. And we see that the prosecutor is asking to introduce what they say is witness intimidation as consciousness of guilt. So tying to Karen Reed, whatever they think they're going to tie to her, to show that she is doing that because she knows she's guilty. And there's a lot of things you can tie to consciousness of guilt. Again, to harken back to the Adelson case, the prosecution's going to seek to introduce her flying on a one-way ticket to a foreign country that doesn't have extradition while her will and affairs are in order as flight showing consciousness of guilt. So the Commonwealth seems to be trying to go in this direction, which they didn't even near in the first trial. And in fact, any conversation about that was kept out of the first case. They go on to say that the Commonwealth's opposition to defendant's motion to suppress and restrain any searching of computer and telecoms devices for unreasonable delay, filed by Special Assistant DA Cosgrove in the Turtle Boy case, and they list the docket numbers, sets forth the relevance contained in 2 cell phones belonging to Turtle Boy that were seized and searched pursuant to a search warrant attached and incorporated herein, which we don't have on the public docket. And interestingly enough, they say that on October 6th, the Norfolk Superior Court endorsed the Commonwealth's motion to search the phones. And on October 14th, 2024, Massachusetts State Police Lieutenant Tully analyzed the extraction reports from the 2 phones. They said that a taint team was established and 4 additional phones were seized from Turtle Boy that have not yet been searched. Remember, Tully testified in the first trial and is Proctor's supervisor boss. They go on to say that the search warrant makes clear that the information expected to be contained on the extraction reports would be material and relevant to the Reed case. They say that the Commonwealth attests that the records are held within the care, custody, or control of the Commonwealth, but given the association between the Reed and Kearney defense teams, the involvement of special prosecutors, the Commonwealth seeks court authorization to obtain material from use in one prosecution for use in another. The special prosecutors are asking the court for permission. So I wouldn't be surprised if the court allows this. They attach an affidavit. Let's take a look at that. Looking at the affidavit of Hank Brennan, he says that following an investigation conducted by a special prosecutor, Turtle Boy was indicted by a Norfolk grand jury for 16 charges related to intimidation and harassment of witnesses in the case of Commonwealth versus Karen Reed. And I know just from existing on the internet that he has denied those and is fighting that case that is still ongoing. It goes on to say, following an investigation conducted by a special prosecutor, Turtle Boy was indicted by a Norfolk grand jury for 1 charge of witness intimidation and 1 charge of wiretap violation, and then that is a separate docket number. He goes on to say in his affidavit that as demonstrated by the search warrants generated as part of the special prosecutor's investigation, the Commonwealth alleges that beginning on or about April 17th, 2023, the defendant took deliberate action to start sharing defense theories, privileged materials, and evidence with Turtle Boy through an out-of-state intermediary. The Commonwealth alleges that the defendant instructed the intermediary to communicate with her through the Signal messaging app, explaining that it provides secure end-to-end encryption, and instructed the intermediary to forward all information to include witness information, home addresses, grand jury minutes, autopsy photos, and generally, they say every piece of evidence that the Commonwealth provided to defense counsel to Mr. Carney. The Commonwealth alleges the defendant would put disclaimers or directives on certain pieces of evidence, such as denoting, quote, do not share, urgent, do not publish anything from the report, and make it clear that he, Turtle Boy, didn't just get it from us. But don't show the exhibits, just read them. Please tell him not to share the title. It has Yannetti's initials in it, DRY, referring to attorney David R. Yannetti. I wonder how they have this information and where this is contained, because these are a lot of direct quotes. It goes on to say, beginning in the summer of 2023, the Commonwealth alleges that the defendant and Turtle Boy would directly communicate on a regular basis. Call detail records from Turtle Boy's phone reveal that Carney and Karen Reed's phone number had 189 phone calls between June and December 21st, 2023, communicating for an excess of 40 hours. This was reported to be in addition to frequent text and phone communications made through the encrypted Signal application. Additionally, they say prior to publishing posts on his platforms, Turtle Boy would seek permission from the defendant or her counsel. On July 14th, 2023, the defense filed an affidavit of Turtle Boy in support of defendant's motion for recusal and disqualification of Judge Beverly Cannone. I didn't know that. That's interesting. So that goes back to July 14th, 2023. We know that was denied. They say that call detail records from Turtle Boy's phone also revealed that phone numbers associated with attorney Yannetti and attorney Jackson communicated with Mr. Carney at least 29 times in 2023. Now, is it the wildest thing that attorneys would communicate with somebody who's covering a story? No. We saw it in the Johnny Depp case. We have seen it in other cases. Is that wild to me? No. And I wouldn't be surprised if that was also disclosed, but I don't know that for sure. But have we seen that in a lot of the high profile cases that we've covered? Yes. Is high profile litigation becoming the Real Housewives, where they are reaching out to people who have podcasts and YouTube channels and giving tea on one another? Yeah, It is. It's very much becoming part of the operation. But whether somebody publishes something on a website or a YouTube channel or a podcast, we've seen that media outlets in this case have sources. So does it surprise me that everyone in this case has a source that they're talking to? No. Emily, what's your source? The documents. I don't want anybody telling me anything. The documents. I just want the filings, folks. But it's interesting the way that the Commonwealth is trying to make that somehow nefarious. Emily, did you say that? Because that's how Hank Brennan said it in one of the hearings. Yeah, it is. When we saw sources alluding to the closing of the federal investigation before it was ever stated in court, when we know the feds don't comment. So is it meant to be shady? Yeah. Do I think it's shady? No. I would be surprised if the Commonwealth is surprised. But they say that a clear inference can be made that the parties directly encouraged Turtle Boy to continue personal attacks on witnesses and their family members, including juvenile children, with the sole purpose to embarrass, intimidate, harass, or deter those individuals from testifying. They go on to say that Turtle Boy publicly stated that the motivation of his actions was to prevent this case from ever going to trial. I can't fact check what the Commonwealth is saying for you or not, because I have not followed everything that happens outside of the court filings in this case. But if that is true, the court is not going to like it at all. This was filed on March 5th. I have to wonder if this played into the swift decision the court made on the March 7th filing, because this is 2 days before, and those cases are still ongoing. So at this point, I'm going with those are allegations because those cases are still ongoing. But it doesn't surprise me that those who look at this case closely say, why is this case going to trial? And based on the things Hank Brennan has said in court, he doesn't really have the benefit of the doubt with me. After what we've seen him say in court, that's just where I'm at with Hank Brennan. There have been so many misrepresentations in court that all of this for me is allegations. And we'll see. Could that persuade the court, though? Absolutely. Don't worry, we're going to get to Brennan correcting the record in just a second. Brennan goes on to say, it has been represented to this court by defense counsel Timothy Bradel on behalf of Turtle Boy that there is, quote, an implicit, long-term implicit mutual assistance and mutual defense agreement between counsel for Turtle Boy and counsels for the defendant. I don't know when that representation was made. And again, if you're not giving me a citation at this point, Brennan, I don't know if that was represented. The benefit of the doubt for me is pretty shot. They go on to say that motions and affidavits filed by the Special Assistant District Attorney make clear that the information produced from both phones are likely to be evidentiary and relevant. The Commonwealth's motion is made in good faith, and the Commonwealth intends to introduce evidence of the defendant's statements and actions to intimidate witnesses from testifying against her as evidence of consciousness of guilt. This may be a very different trial, but it's going to be a frustrating one if we have a prosecutor that keeps making misstatements in court. Let's take a look at the motion to correct the record. Affidavit of Special Prosecutor Hank Brennan to correct the record. In oral argument, I provided a number of examples of extrajudicial statements that have been made by defense counsel, as well as examples of in-court statements made relative to the now closed federal investigation and the potential impact such statements may have on the jury pool. One of the examples I cited to support my commentary about the now closed, he's going to say that a lot, about the now closed federal investigation was a statement made by Attorney Yannetti. I, quote, inadvertently and mistakenly characterized one of his statements as an extrajudicial statement. The statement by Mr. Yannetti was not an extrajudicial statement. It was a statement made during a Zoom court hearing in the Reed case, which is what Yannetti said in court. Yannetti said, I think that was during a hearing. Advocacy in court cannot be sanctioned in this way. Brennan was saying, look, Yannetti's on the media in court TV saying this. Well, Brennan says the statement by Yannetti was not an extrajudicial statement. It was a statement made during a Zoom court hearing in the Reed case. The statement was aired as part of a segment posted by Court TV entitled Karen Reed's attorney talks federal investigation with Court TV. Are you making statements in court based on headlines? What? The segment included a story regarding the case. The 41-minute and 21-second segment includes a Court TV anchor's story of the case, witness interviews, and some clips from the court hearing, including a Zoom court hearing. The quote from Attorney Yannetti was from a statement made during Zoom court. I mistakenly stated that Attorney Yannetti's statement was an extrajudicial statement. My mistake was unintentional and regrettable. Unintentional and regrettable? Isn't that the marching line from Trooper Proctor? Is regrettable just the default? You have a duty to the court, both sides do, to say, I remember a statement made on Court TV. But if you're not clear that that statement was not clipped from a court hearing, you can't present it as if the attorney's giving an interview to Court TV. Just because Court TV put a court hearing on their channel, which is like what they do, you can't say it's an extrajudicial statement. Brennan is not careful with what he says at all, which is why even in his affidavits, I'm just like, no. I need citations because it's gotten wild. It is regrettable. I think people hoped that someone was going to have a clear look at this case. And what we're getting is, well, maybe not a clear look. At least we found out that the video had apparently all been recorded and withheld from the defense at some point. I guess it's not wild to me, but it does cause me grave concern. We should take a look at what else the Commonwealth wants. Also filed March 7th, the Commonwealth would like an extension of time to file motions in limine related to the defense experts' reciprocal discovery. They said the Commonwealth has not received further disclosures relative to the ARCA witnesses, nor has the Commonwealth received reports or anything beside a CV for the two noticed experts. For those witnesses, the Commonwealth reserves their right to file motions in limine at a time after the required disclosures have been provided. The Commonwealth anticipates filing all other motions in limine on Monday, March 10th. So the Commonwealth is like, where's our discovery? I'm sure that the defense can relate to the feeling. I imagine the court will allow them a bit more time because it is hard to make motions if you don't have the discovery, which is kind of what the defense has been arguing over the last several weeks and beyond. We learned so much more about what the defense didn't have last week in court. I'm still a little bit reeling from it, and I think everyone is rightfully frustrated by it. The intentional withholding of evidence is incredibly frustrating. I'm truly most surprised that we learned more about it still, and that's concerning. Speaking of not having discovery, the defense has filed additional exhibits. We're going to take a look at that real quick because, well, no motion left behind today because by the time I'm back from spring break, there's going to be plenty more, I'm sure. This was also filed March 7th. This is the supplemental exhibits in support of the defense's motion to dismiss. Exhibit 1 is a corrected version of the inverted interior Sally Port garage video. So this was the inverted shit that was flipped and then they flipped it back. Counsel specifically directs the court's attention to 115 through 149, during which time Trooper Proctor appears and has unfettered access to the right rear taillight of Miss Reed's SUV. Surveillance footage also shows an unidentified individual, quote unquote, apparate, and then disappear from the frame near the right rear taillight. Exhibit 2 is a photograph of the condition of the right rear taillight of Miss Reed's SUV in the Canton Sallyport on February 1st, after Trooper Proctor and others had access to it. They say the taillight then appears fully damaged, not cracked. We went through some of those videos on stream at the end of stream last week. Exhibit 3 is a photograph of reconstruction of taillight with pieces of plastic recovered from 34 Fairview. Even after the full reconstruction of the taillight, it appears cracked and missing a piece consistent with Sergeant Barros's testimony. Again, we talked about this at the end of stream. And I think somewhere on stream I had said 17 pieces, not 47, because it's still hard for me to wrap my head around how this taillight broke into 47 pieces without causing significant damage to the thing that broke the taillight. Because taillights on new vehicles don't just break. Exhibit 4 is a photograph of 47 pieces of plastic taillight lens material recovered from 34 Fairview. Exhibit 5 are screenshots establishing Commonwealth's Exhibit 2, which purports to show the interior Sallyport back wall camera was also inverted on 1/1/2022, has a different color chyron, the date timestamp, than the 1/29/22 inverted video produced on April 4th from the same camera, which is what Jackson had said in court. I think I remember them being a different color. He argues then that the discrepancies suggest manipulation and further underscores the prejudice to misread. I think for me, it highlights the need for an evidentiary hearing to ask the person who downloads the video, WTF? Why would this download in this color and that download in that color? I think if there is an explanation, the court should have a hearing and figure out what the explanation is. Bring in the witness. And speaking of bringing in the witness, that seems to be exactly what the judge wants to do with the Commonwealth's dog bite expert in a ruling that I was quite surprised to see and quite surprised at how it went. And if you're just getting ready to leave a comment in the comment section being like, Emily, your transitions are on point, I know. But the extensive amount of time it takes behind the scenes to get this episode recorded is much. So if you don't want to miss that, you need to make sure that you are a member either on YouTube or in the Lawnerd Lounge, because then you get to see, how we do it in real time. But let's talk about this court order ruling from March 6th that I was just, really surprised by. Emily, you shouldn't be surprised by anything at this point. You're right. You're right. I shouldn't. But I still have expectations. And I seek out consistency in rulings. And I will say this about judges all the time, even if I don't agree with the way they rule on a particular thing, I expect to see consistency. And there were times most memorably to me, some of Judge A's rulings with regard to hearsay and dep heard. I didn't agree with the way she ruled on certain aspects of hearsay, but it was incredibly consistent. It was the same ruling all the way across. And so even if I disagree with the ruling, I can respect if it's consistent, because it means that the court is like, this is how I see this, and I'm applying it equally. I expect consistency. I want to see consistency. And I don't know what the fuck this is. So what it's not is consistency. Decision and order on defendant's motion to exclude the testimony of the Commonwealth witness James W. Crosby, PhD. Quote, after hearing and review of the pleadings, the court finds that the Commonwealth has satisfied the foundational requirements of Daubert-Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony, principles, and methods employed are reliable. The defendant's objection goes to the weight of the evidence, not its admissibility. Order. Defendant's motion to exclude the testimony of James Crosby is hereby denied. March 6th. So, if the dog behavior PhD can testify to the medical cause of wounds to John O'Keefe, why can't the biomechanical engineers? So, is the rule that in Massachusetts, the medical cause of injury has to be testified to by a doctor? Is that a rule based on case law, statute, or vibes? Because it seems like it's based on vibes. I remember the court saying in Massachusetts, unless you are a doctor, and I'm paraphrasing, you cannot testify to the medical cause of injury. Then why is the non-MD allowed to testify about the cause of injury? And how will the court exclude that testimony from ARCA this time? Because I don't think that you can. It's either the rule or it's not the rule. I am very surprised that when the court had a lengthy Daubert hearing with regard to the defense expert, an MD in multiple areas, the court was not clear about whether that expert, Dr. Russell, would be qualified. But without a hearing, here the court does not limit the testimony, does not ask more questions, and does not find it to be a close call. The inconsistency of the rulings we saw in the first trial and this ruling are glaring to me. I expect that the defense will be making motions to open up the door about what perhaps Dr. Russell could expand on and what the ARCA experts can expand on. And maybe the court will open the door to that, because if the rule is that you have to be a doctor, then this testimony is not allowed. But if that's not the rule, why was it the rule in the last trial? I'm going to be very interested to see what happens from here. But I am surprised about this ruling based on how strongly the court ruled and how confidently the court ruled against the biomechanical engineers. So, doctor or not a doctor? It seems that not a doctor is fine. So let's hear from everybody. Let this in. Let the ARCA experts in. Fine. Bring it all in then. I think that's the only thing that can happen from here. I am deeply concerned that the court doesn't cite any case law regarding the rule in Massachusetts, which is exactly what she said, the rule in Massachusetts, that only a medical doctor can testify. Because the rule's not in that ruling. So then why was it the rule in the first trial? Well, we're probably not going to get to hear what the defense has to think about it because there's now a gag order in this case. So let's get to that one, shall we? I know I gave away the punchline a little bit on this, but this is the court's memorandum of decision and order on the Commonwealth's motion to impose sanctions pursuant to Massachusetts Rule of Criminal Procedure 48 and oral motion to prohibit prejudicial extrajudicial statements of counsel. Also, fuck off everybody with putting prejudicial extrajudicial in the same sentence because it is impossible to make the mouth behave correctly. This was from March 7th. The court says there have been more than 500 filings in this case, many of which are subject to protective orders. This case has generated significant media attention locally and nationally, with the defendant and defense counsel participating in numerous interviews with media outlets. And the court is aware that there was a federal investigation into the investigation of O'Keefe's death. Recently, the Commonwealth represented in open court that the federal investigation has concluded without issuance of any indictments. Before the court are two motions, a motion to impose sanction, and an oral motion made by the Commonwealth to the court on March 4th, renewing its prior written motion seeking to prohibit extrajudicial statements of counsel. Because Brennan was allowed to just add to the motion. Brennan never renewed formally that prior motion. He just kind of slipped it in as he was arguing about sanction. Was like, by the way, make the defense file everything under seal. I have never seen a request like that. I have seen in Idaho, both parties file things under seal. And then if they need to be redacted and unsealed, then they are. But the caution in Idaho is that most things are filed under seal and redacted and then released later. And it's at the attorney's discretion, and the attorneys seem to have worked well together. But it's not one-sided. Both parties file most things under seal. But Brennan just added it in. And he's done that every single motion that we've seen him argue. He's just added more. And that request is wild. Make the defense file everything under seal. And then if the Commonwealth thinks it's okay, then it can go on the public docket. It's preposterous. So the court has cleaned up that the prosecutor just kept talking in court and said that the prosecutor renewed its prior motion. For the reasons that follow, the court will deny the Commonwealth's motion for sanctions and allow the motion for an order limiting extrajudicial statements. To be fair to the court, the way that the court executes this order is by lining out the professional rules of conduct again. And those are the same professional rules of conduct we've seen being argued in New York in Lively Baldoni et al. It's the same rules of conduct we saw early days argued in Idaho regarding their gag order. It's the same rules of professional conduct that come from the model rules. So the court just reiterates the rules that are already applying. So is it allowing the motion? Yes. But is it really doing more than saying that the rules that apply still apply? Not really. But the court did deny the Commonwealth's motion for sanctions, which to me is a good sign. But also, I don't think sanctions are where we should have gotten to with this in the first place. I think the court was more concerned with statements made to the court than with anything put in a written filing. The court says that the Commonwealth's motion for sanctions is in response to the defendant's motion to reconsider reciprocal discovery, wherein defense counsel quoted information subject to protective orders issued by this court on November 13th and January 31st. Attorney Yannetti has acknowledged that this motion, which was not protected from public view, should not have included protected information. However, he represents that the inclusion of protected information was a mistake and not a willful act. As a sanction for this conduct, the Commonwealth requests the court issue an order that the defense file all motions under seal and impound it until such time that both the Commonwealth and court can ensure that the filings comply with all previous orders set by the court. The sanction sought by the Commonwealth is not appropriate under Rule 48. Rule 48 allows for the imposition of punitive sanctions on individual attorneys who intentionally violate the rules of criminal procedure. And that can include, she goes on to say, fines or referral to like the bar, etc. Although procedural remedies such as the initial impoundment of documents sought here are available under other rules of court, see the Uniform Rules of Impoundment Procedure and the Trial Rules of Court, defense counsel has assured the court that it will take more care in the future with protected information in its court filings. The court therefore declines to impose any sanction under Rule 48 at this time. However, subsequent or repeated violations of court orders may well be considered either willful conduct or careless indifference that warrants sanctions by the court as permitted by the rules. So the court has said to the defense, I believe what you said. I believe your representations. Going forward, if you are not more careful, then I might change my mind. And I think the way that Yannetti laid it out in court was appropriate. Yannetti said, this shouldn't have happened. I apologize to the court. It is completely my mistake. Didn't try to explain it away, but tried to assure the court that it was not willful and that the harm generally sought to be protected in protective orders wasn't caused here. It wasn't really anything new that was unknown. It wasn't something that puts anyone at risk, that kind of thing. So Yannetti's statement to the court was clearly taken well by the court. And the court said, no, if we have issues going forward, then maybe. But for now, no. And I think that reminder to defense is really what's appropriate here. The court goes on to say that the Commonwealth seeks a gag order to prevent defense counsel from making extrajudicial statements in violation of Massachusetts Rules of Professional Conduct 3.6a and from revealing protected information to the public through media. In June 2023, the Commonwealth filed a similar motion to prohibit prejudicial extrajudicial statements of counsel in compliance with the same rule of professional conduct. The court denied that motion, concluding that no trial date had been set and that this minimized the likelihood that extrajudicial statements would materially prejudice the proceedings. In so ruling, however, the court emphasized that all counsel are bound to comply with the standards for attorneys with respect to extrajudicial statements. At the March 4th, 2025 hearing on the Commonwealth's motion for sanctions, the Commonwealth reasserted its request for a so-called gag order, arguing that defense counsel have violated Massachusetts Rule of Professional Conduct 3.6 by making extrajudicial statements that counsel reasonably should know will have a substantial likelihood of materially prejudicing the proceeding in this matter and have put protected information in the public domain. In support of its oral motion, the Commonwealth asserted that the defense lawyers have a history of making extrajudicial statements that may prejudice the proceedings. It also submitted audio clips from an interview conducted by Boston Magazine reporter Gretchen Voss of the defendant and attorney Jackson at the Omni Seaport Hotel on July 13, 2023, and cited to a recent interview that aired February 17, 2025, that the defendant and attorney Jackson gave to Fox 25 News. And those are both footnoted. Based on these interviews and defense counsel's consistent publicly reported interactions with reporters and bloggers throughout the first trial, the court agrees with the Commonwealth that an order limiting extrajudicial statements of counsel is both appropriate and necessary to ensure a fair and impartial trial, and finds that no reasonable, less restrictive alternative to the order is available. During the Voss interview, the defendant, with attorney Jackson seated at her side, told the reporter about witness testimony from the defendant's sealed grand jury proceedings. This is what was filed under seal. I have not yet read all of this interview, but I don't know if this part made it into the interview or if this just is part of the notes that got turned over in discovery. Specifically, the court goes on to say in her very public order, while discussing Voss's recent visit to the Waterfall Bar and Grill, the defendant stated that the bartender who works there had testified before the grand jury. After further conversation, the defendant then told Voss the substance of the witness testimony before the grand jury. The requirement that grand jury proceedings remain secret is deeply rooted in the common law of the Commonwealth in order to protect the process from extraneous influences, protect individuals from notoriety and disgrace, protect witnesses from intimidation and subordination, and encourage a free and full disclosure of information concerning commission of a crime. And that cites WBZ TV versus the District Attorney's Office. The reason the court knows that this came from sealed proceedings is because the defendant is not at the grand jury. The only way the defendant can produce that information to reporter Gretchen Voss for the court to put it in an order and produce it to all of us is for the defendant to read the transcripts, because the defendant and the defendant's attorneys aren't there. But it's wild to me that while this was redacted out of the motion and the notes and the audio from the interview that then became, I believe, a written piece, that was all impounded. The court discusses it full-throatedly in this order. So I'm left a bit baffled, flummoxed, if you will, that after all of the attorneys redacted all of this and the notes and the audio and the video from the Gretchen Voss interview were all impounded, that the court puts it in the order. What? What are we doing? Continuing on, the footnote says, although this interview was conducted on July 13th, 2023, the Commonwealth only recently obtained the audio and shared it with the court. The other footnote says, at the hearing on the motion, prosecutor Brennan also stated that attorney Yannetti appeared on Court TV, falsely representing the subject of the federal investigation. In fact, Court TV played a clip of statements attorney Yannetti made on a Zoom hearing in court. Thus, contrary to the Commonwealth's representation, the statements were not extrajudicial and thus are not considered for this motion. So at least the court cleared up that the court's not considering Brennan's misrepresentations in court. So at least there's that. The court goes on to say, additionally, during interviews with both Voss and Fox 25 News, attorney Jackson disparaged witnesses in this matter. The court is not going to like this at all. In the Voss interview, he specifically referred to two witnesses as liars. Statements commenting on the character, credibility, or reputation of witnesses are more likely than not to have a material, prejudicial effect on a proceeding. In the subsequent Fox 25 interview, the court goes on to say attorney Jackson claimed that, one, although individuals involved in the case know what really happened, they are not talking, and two, witnesses in the Albert home the night of January 28, 2022 had obtained lawyers for, quote, self-preservation, which implies that they are not being truthful in their statements to law enforcement about what occurred. In the decision on the Commonwealth's first motion to prohibit extrajudicial statements, the court noted, quote, the defense counsel's statements to the media had at times arguably crossed the line of permissibility under 3.6. but concluded that the risk of prejudice was minimized by the fact that no trial date had been set. With trial now imminent, and with the above-mentioned examples of improper statements made directly or indirectly by defense counsel, the court is no longer satisfied that the less restrictive alternative to the order previously given, the reminder to counsel that they are bound by the ethical and procedural rules, is sufficient to ensure a fair trial in this matter. The court finds that there is a substantial likelihood of continued comments about witnesses and evidence in this case by counsel in the future that might well taint the jury pool. Therefore, an order restricting such statements is now both appropriate and necessary. And then the court orders a gag order and lines out the rules of professional responsibility. Again, we missed one footnote and we're going to cover it. Footnote 3. The court also notes that Attorney Jackson had a conversation with Voss at the Omni Seaport Hotel, during which he revealed information that had been turned over by the Commonwealth in discovery, but not yet made public. In that discussion, Attorney Jackson acknowledged to the reporter that he was not permitted to disclose the information that he received in discovery and told her she could not publicly disseminate the information until it was put in a court motion. Attorney Jackson then proposed a way to make the information public in an unrelated court hearing so the reporter could put it in her article before publication. The court is not going to be happy with that either. Trying to strategically use court filings to place information that is not supposed to be in the public purview ahead of a trial to influence a jury pool is not something the court looks favorably on. But the court also hasn't really smacked down the prosecution for just saying stuff in court that has no basis. So how mad can I be about all of it? At this point, I'm just mad at everybody. What is happening with this case? How are we still here? It's clear from the court's issuance of a gag order that the court is not happy with Attorney Jackson. We know that from their interactions in court. There are still numerous things that haven't been ruled on. But with regard for the motion for sanctions, at least that motion is now ruled on. I think there was a lot of concern, at least that's what I've seen in the comments in the live streams, about whether or not the court would take direct action against Attorney Jackson. And what we are seeing here is the court saying, I am not issuing sanctions. I am telling you all to stop talking to the media, and that's it. So for how frustrated the court seems to be and took the opportunity to point those out in footnotes, the court did not go further with sanctions, which I think is what a lot of people thought might happen with regard to Attorney Jackson. With the gag order, I think it might be a bit too late. The shit's kind of already out of the horse. Could there have been more interviews leading up to trial? Of course, there's still a little less than a month left. It's going to limit what the defense can say when they are entering and exiting court to the media and not making any statements. But also, maybe it will let everybody focus on figuring out what's happening with this evidence, because the motion to dismiss is still looming. So is a ruling from the federal court. There's a lot of litigation left to go in this case. And it's going to be most of what we're talking about until this goes to trial, because there is so much happening in court, out of court and filings, and there are numerous court days still ahead of us with motions in limine. So I will be covering all of that when I am back from break. Thank you for being here. Thank you for being a Law Nerd. Don't forget to get the Law Nerd app so that you can be in the loop when I go live, when we're covering live court, and when new stuff pops off, because court is busy this year. Thank you for being here. Thank you for being a Law Nerd. Take care of yourself, and may the odds be ever in your favor. I'll talk to you soon. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.